Hello and welcome to lecture 2 for topic 8, and in this lecture we're going to be looking at warrantless searches. Okay, so as I mentioned in the last lecture, that getting a warrant for a search is preferred, but it's not always practical to get a warrant. Taking a warrant gets time, and sometimes there's just not enough time to get a warrant, particularly if it's an emergency situation and lives are at risk. And so there are times when it's reasonable to waive the warrant requirement. Keep in mind, as we talked about in the last lecture, that Chief Justice Roberts says that it's not a warrant that makes a search reasonable. But the question is the search itself reasonable, whether or not there's a warrant? So reasonableness is the touchstone of the Fourth Amendment. And so for a search to be constitutional, the search needs to be reasonable, and sometimes it's reasonable to allow a search without a warrant. And so a search without a warrant is known as a warrantless search. And these warrantless searches can be legal if they're within the scope of the exceptions that are outlined by the court. So sometimes students get confused and they say that a warrantless search is an illegal search. That is not the case. A warrantless search is legal as long as it meets the exceptions that are outlined by the court. So let's get started. So as we're learning about these different exceptions to the warrant requirement searches, I want you to keep the following things in mind. One thing I want you to think about is, what is the reason for the warrant exception? What's the reason that the Supreme Court gives for allowing these searches to take place without a warrant? I also want you to ask yourself about what's the scope of the search. So when you get an exception for the need to a warrant, are there any sort of limitations that are placed on the search? So keep that in mind. And then as you're learning about these searches, even though the Supreme Court says that these warrantless searches are constitutional, do you disagree with the Supreme Court? Do you think that any of these searches should not be constitutional or legal searches? Do you disagree with the assessment of the Supreme Court? So these are the different searches, warrantless searches we're going to be learning about. Exigent searches that take place in exigent circumstances, search incident to a valid arrest, automobile searches, consent searches, and the stop and frisk searches, also known as a Terry stop. In our last video, we learned a little bit about the in plain view exception, and so that you can read more about that in the textbook. We're not going to talk about that in this lecture. Searches that take place in exigent circumstances, there's no need for a warrant to do those sorts of searches. Exigent basically means an emergency or a situation that needs urgent action. So no warrant is needed if the circumstances that law enforcement are faced with require immediate or urgent action. Some examples of exigent circumstances that your textbook talks about are hot pursuit. And so if police officers see a crime taking place, let's say a shootout in the road or on the sidewalk, and then the shooter runs from the scene and then runs into a nearby house, the police don't need to stop and get a warrant in order to pursue that individual into the home, because it's a dangerous circumstance that they are able to pursue that individual without a warrant. Now, there has to be probable cause that the perpetrator is actually in the house. It has to be a serious crime. And that the thinking is that there needs to be immediate apprehension of that individual, because if there isn't, then more dangerous, life-threatening things could happen. If evidence is likely to be threatened, that a law enforcement can engage in a search without a warrant. The example that they use in your textbook is drawing blood from people without a warrant when they are intoxicated and driving. The idea is if you have to stop and wait and get a warrant, that enough time could pass so that that the evidence would disappear, and that the individual then who is drunk would not be held responsible for their actions. So the Supreme Court has made some exceptions for threat to evidence. Hostage situations, threat to others, and so if there are dangerous people that are holding other people hostages, or potentially hiding out in dangerous people or hiding in homes in order to evade apprehension, that in those instances, the Supreme Court has made exceptions to allow those searches without a warrant. Why those searches are allowed without a warrant is because lives are in danger and evidence is in danger. And so basically, the Supreme Court does a balance, and they say that the damage that comes from the warrantless search is less than the damage that comes from the potential danger that the dangerous suspect is presenting to the community. And the scopes of the exigent circumstances can be limitless. That as long if an emergency exists. So I use the example of the Boston Marathon bombing that took place many years ago. And when the police were searching for the two bombers, they had an idea that they were hiding in this a certain neighborhood within the Boston area. And the cops went there, and they didn't stop and get a search warrant for each of the homes. They were able to enter into those homes because that this was a dangerous emergency situation, and they really worried that lives were at risk. But if there is no emergency, then you are not allowed to engage in these kinds of warrantless searches. And once the emergency is over, then the warrantless searches can no longer take place. Another exception to the need for a warrant is searches that take place at incident to arrest. And so police can search a person and the immediate area around that person after an arrest without a warrant. And that comes from the case Schimmel versus California. In that case, an individual was arrested. The police came to the home. They had an arrest warrant. They arrested that individual, and then the cops engaged in a whole house search. And the individual cried foul, said that search was not allowable, and the Supreme Court agreed. They basically said that you can search somebody at arrest, but that there are limits to the search that you do without a warrant. That the limits are that the search must immediately follow arrest, and it's only can be a search in the immediate area that the arrestee has within their control. It's oftentimes known as the grabbing area. So just because somebody's arrested doesn't mean you can search their whole house if you arrest them at their house. The search has to be of the person and of the immediate area around the person. If the arrest is invalid, then the search is invalid. And so if the person shouldn't have been arrested and then a search takes place, or if the person shouldn't have been arrested, but then there was a search incident to that arrest that produces contraband, that contraband is inadmissible. Why? Because the arrest was illegal. It's allowed, these kinds of searches are allowed without a warrant, mostly for officer safety. And so you want the officer to be able to immediately search that area and the person, because if you waited for a warrant, then in that time, that arrestee could maybe reach down, even though they're handcuffed, and like get a knife out of their boot, or try to hide or dispose of evidence, right? So there's, officer safety is the primary concern when it comes to these searches incident to arrest. And the scope is limited, as we know from Schimmel. It can be a full body search, and the grabbing area, anything that's within grabbing area of the arrestee, but anything beyond that would be considered an unlawful search without a warrant. So automobile searches can be police can engage in an automobile search without a warrant. There's a lot of information in your textbook about the automobile searches, so I won't go into a lot of detail here. I'll let you read more of the details in the textbook. I'll just give you the broad outlines of automobile searches and what the Supreme Court has said about it. They've said that cars can be searched without a warrant if police have probable cause to believe the car contains evidence that they're seeking. And that's from a case about a bootlegger, Carroll versus the United States, that there was probable cause to believe that the person driving the car was trafficking in illegal alcohol. They pulled him over, stopped him, and then searched his vehicle and without a warrant. And the Supreme Court said that was allowable because they had probable cause to believe that there was evidence in the car. Now, engaging in that kind of search of a home would not be allowed, right? A warrantless search based on just probable cause of a home would not be allowed. so why a car? Why is a car allowed to be searched without a warrant? Well, there's two things that the Supreme Court has kind of considered with the warrantless search of vehicles. One is, and this had to do with the Carroll v. U.S. Case about the transporting of illegal alcohol, that they said that the state had a heightened interest because cars are mobile. Okay, so since cars can move from one place to another quickly, that it kind of increases the kinds of criminal activity that can go on, right? Because you're in a mobile car. And so that the state has a greater interest in being able to search that vehicle without a warrant, because that the state is, faced with a greater challenge of the mobility of crime, right? And so they allowed that search based on probable cause, but without a warrant, because cars are mobile and able to engage in criminal activities in a way that moves from, municipality to state, right? And so they allowed that. Whereas searching a home just based on probable cause, well, the state doesn't have a heightened interest there because the home's not going anywhere, right? They can take the time to get the warrant. Another thing the court has looked at when it comes to automobile search is the reasonable expectation of privacy. That the courts have said that the cars just get a lower level of Fourth Amendment protection because they're not fully private. They have windows, right? That what you're doing in the car is subject to the scrutiny of others, because you're just looking over at the car and you're like, shit, that person has a dead body in their car, right? Because we can see into your car. And so it's the combination of because the car, there's not as high of a level of expectation of privacy with the car and the fact that it's mobile, that the Supreme Court has allowed law enforcement to engage in automobile searches with probable cause, but without a warrant. The scope can be pretty vast, and you can read about it in your textbook. With probable cause, the car can be searched, the driver can be searched, the passenger can be searched, the trunk can be searched, containers, the glove box, all of that can be searched possibly during an automobile search. It's not limitless, so you can read about the limits that are placed on automobile searches. That if a person is pulled over and then they get a ticket for having an expired license, that doesn't open that person up to a search of the vehicle, because there's nothing in the vehicle that you would find that would be related to the probable cause that this person has committed a crime, right? All it is that, the crime is you were driving on an expired license or driving without your registration, right? It was you were a registered or driver. The evidence you need is on the driver's license. That's it. There's not extra evidence you're going to find in the vehicle. So there are limits in terms of the automobile search, but the Supreme Court has really created pretty wide berths for law enforcement to engage in automobile searches. Read more about it in the textbook. So if you consent to a search, police can search, okay? And so police do not need a warrant if they ask you, can we search you, or can we search your vehicle, or can we search your backpack, and you say, sure, go ahead. If you consent to a search, police can search. And why is this allowed without a warrant? Well, because you can waive your Fourth Amendment rights. You have those rights and you can exercise those rights, but if police ask you, can we search you, and you say, sure, go ahead and search you, you have the right to waive your Fourth Amendment rights. There are certain scope or limitations to a consent search. One is the consent search is the scope is as far as that consent sort of leads. And so let's say that you get pulled over by police for speeding and you're issued a ticket. That does not, open the door to, if you get a ticket, police can't search your vehicle without a warrant, because there's no probable cause that you've engaged in a crime other than the speeding, right? And so you get the ticket for that. But let's say you get pulled over and you get a ticket for speeding, and then cops say to you, hey, do you mind if I search your trunk? Like, yeah, no, sure, go ahead and search my trunk. And then as the cops are walking back to your trunk, you're like, oh shit, I forgot about that dead body in the back of the trunk. If they open up the trunk and they're like, dead body, at that point, there's probable cause that a crime has been committed. You would be arrested, and then they could search the rest of your vehicle for evidence of that crime. Okay. So the consent leads to finding contraband, then that can lead to a fuller search of the vehicle. But if you go and they say, go ahead and search my trunk, and they don't find anything, that doesn't, police can't then go and search, your glove box or search the back seat of your car. The consent is limited to the consent that has been given. The consent also needs to be voluntarily and intelligently given. So oftentimes when a person consents to a search and contraband is found, that the criminally accused will make that the state has to demonstrate that consent was actually voluntarily and intelligently given. And so if the person's drunk and they consent, well, that's not intelligently or mindfully given. And if there's a lot of coercions that's used that could be demonstrated, then that would not be an allowable search. Your textbook talks about limited third-party consent. And so if you live in a home with roommates and police come and say, hey, is Johnny home? And you say, well, no, Johnny's not home right now. And then the cops say, well, do you mind if we go and search Johnny's room? And then your roommate says, yeah, sure, go ahead and search Johnny's room. And they go search the room and they find something. That would be an illegal search because the roommate can only give consent to their room and the public area within the apartment, right? So like the living room or the kitchen, something that everybody can use. But your roommate doesn't have the power to give consent to search your roommate's room, right? Because that's their own private area. And so read more about the limits of third-party consent as it relates to consent searches. And if you refuse to consent, this doesn't constitute probable cause. And so if cops ask, can we search your trunk? And you say no, they're like, well, you must be hiding something. Probable cause, we're going to search you. No. But on the flip side of that, if cops ask you, can we search your vehicle or search you, they don't have to tell you that you can say no and you're free to go, right? There's no obligation for them to say that. And so you can't say that, well, I gave consent because I didn't know I was free to go. The Supreme Court does not say that the law enforcement have to tell you that you can refuse a search and you're free to go. Now, some states will have that on their book that the law enforcement have to tell people that if they don't consent to a search, they're free to go. But there's no constitutional obligation to do that. The last warrantless search we're going to be talking about is the stop and frisk, and it's probably the most controversial of the allowable warrantless searches that you'll read about in the textbook. So no warrant is needed by police to stop and search in suspicious circumstances. These are oftentimes known as Terry stops or Terry searches because it comes from the Supreme Court case Terry v. Ohio. What's controversial about the stop and frisk is that you don't need probable cause to search, but it's a lower threshold. It's the reasonable suspicion threshold, not the probable cause. And what makes it controversial is that it's like if you live in an urban area in a high crime neighborhood, that just being outside could be seen as reasonably suspicious, right? At later in the evening, or maybe not even later in the evening. And so because the threshold is lower, reasonable suspicion, it really opens it up so that cops can potentially search anybody sort of living in that neighborhood. Now keep in mind that the stop and search are separate acts. That your textbook talks about the example of, let's say law enforcement are driving around their patrol car and they see two individuals who are like in the parking lot of a convenience store and they're talking to each other, and then a car drives by, they're sort of talking to people in the car, and then drives off, and cops might say, hey, that seems reasonably suspicious. What's going on here? And then they go and talk to the individuals and stop them, ask them some questions, and they say, hey, what are you guys doing here? And then these people say, oh, we're the security guards for this convenience store. At that point, you can stop because it's reasonably suspicious, but then you wouldn't be able to search because to search would be it would not be legal because that there is no more suspicion. These individuals are supposed to be there. They're security guards. Now, if you stop and you say, "Hey, what are you guys doing here?" and the people seem really edgy and they're like, looking really nervous and they're not answering the questions, well, then a search can be conducted because the reasonable suspicion continues. So the stop and search are separate acts, and the search still must be reasonable. It needs to be based on sort of the evidence that you get that's derived from the initial stop. Sorry about the dogs barking. And like I said, that you can look at the security guard example in your textbook. Why are stop and frisks allowed? Well, they're allowed, again, for two reasons. Officer safety. So as officers are patrolling and they come upon people in a suspicious area, that they want to make sure that the officer, as they're questioning them, if the suspicion continues, that they can do a pat down to make sure that that individual doesn't have any weapons. Also, as we saw in the Cops See Things Differently video, that the stop and frisk is, can be used as a disruption of crime fighting, right? Gives people the opportunity to stop and ask, or cops stop, ask questions. What are you guys doing here? And if the suspicion continues, then you can do a pat down, and it's a better way of fighting crime. Of course, it can also be abused, right? Because it provides such a wide berth for searching, and also that individuals who live in higher crime areas then have lower Fourth Amendment protection than people living in nicer areas, and that seems fundamentally unfair. The scope is limited to the stop, ask questions, and then a pat down of the outer garments. The search can't go beyond that. If you pat down the outer garments and you don't find anything, the search can't continue on from there. The law enforcement would have to stop it at that, particularly if the point is officer safety and crime fight. Okay, so as you're learning about these different searches, you should be able to describe each of these searches. You should be able to explain what is the reason for the exception for the need to a warrant, what's the scope and limitations of the search, and of these that you've learned about and that you read about in the textbook, are any of these, do you think they should not be legal searches? Do you think that the Supreme Court has gone too far in terms of allowing law enforcement to engage in searches without a warrant? Okay, that's it for this week, and I will talk to you again next week.